Welcome to the Kelly Consulting Firm's presentation on discrimination and harassment. My name is Dr. Robin Kelly, and I have over 20 years experience working in human resources, management consulting, equity, diversity, and inclusion, equal opportunity, employee relations, and I have been an independent consulting since 2015, and I started Kelly Consulting Firm. Well, let's get into the presentation. What is discrimination? Discrimination is conduct that can include a broad spectrum of disparate treatment directed towards an individual or group of individuals based on a protected class that adversely affects their employment or education. Discrimination includes denial of requests for reasonable accommodations based on a disability or religion. I mentioned previously that discrimination is adverse treatment based on a protected class or protected classes. The protected classes include race, color, religion, national origin, sex, gender identity, age, disability, veteran status, genetic information, sexual orientation. Now, these are the federally based protected classes. Each state may have additional protected classes, but for the purpose of this presentation, we're going to just list the federally protected classes. Next, we're going to talk about the theories of discrimination. And the theories of discriminations are the framework for any investigations or any complaint handling. There are primary theories of discrimination. Desperate treatment is when an individual is treated differently or less favorably because of their protected class. Desperate impact is a policy, practice, rules, or other systems that appear to be neutral but result in a disproportionate impact on a particular protected group. Harassment is when an individual has been subject to unwelcome conduct based on their protected class. Accommodation is when an individual needs to be treated differently because of a disability or religion and they're not. Retaliation is any adverse action against an individual because that individual engaged in a protected activity. So for example, filing a complaint, a request for a reasonable accommodation would fall under this category. So how does a complainant establish a prima facie case for discrimination? Well, the complainant must be a member of a protected class, and a protected class, as I mentioned earlier, falls under race, color, religion, sex, age, national origin, disability, genetic information. That's the first prong. And this is typically self-identified. Then the complainant must demonstrate that they experienced an adverse action. So some examples of an adverse action is academic action, such as someone, receiving poor grades or not receiving an award or receiving negative recommendations or evaluations, or, failing to provide an otherwise reasonable accommodation for a disability or religious belief can be considered an adverse action. That is the second prong. And then the third prong is a similarly situated individual of a different protective class than what the complainant is saying that they are, was treated more favorably than the complainant. So the three criteria for establishing a prima facie case of discrimination is the complainant is a member of a protected class, 2, they suffered an adverse action, and then 3, a similarly situated individual was treated more favorably than the complainant. Establishing a case for desperate treatment. I had mentioned to you before that for a complainant to establish a prima facie case of employment discrimination, the complainant must demonstrate that they're a member of a protected group or class, and the complainant was subject to some adverse action. And then 3, that a similarly situated individual was treated more favorably than the complainant. Then the burden shifts to the employer. The employer then has the burden to articulate some legitimate non-discriminatory reason for its actions. So for example, if the complainant failed to receive a raise and the complainant filed a complaint saying I was discriminated against, the employer then has the burden to articulate some legitimate non-discriminatory reason. So, for example, the employer comes back and says, well, the reason why the complainant didn't receive a raise is because she had a poor performance evaluation. And that would be a non-discriminatory reason or an example of one. Well, then the burden shifts back to the complainant, and the complainant must show by a preponderance of the evidence that management's stated reason is actually pretext or a mask for discrimination. And so, say the complainant comes back and says, actually, John Doe, who is male and I'm female, received a poor performance evaluation as well, but he received a prorated amount of his raise. And so he received a raise, but I received nothing. So that would be an example of providing evidence by the complainant that the actual stated reason by management was actually pretext or a mask for discrimination. Many times in disparate treatment cases, they can be proven or show or demonstrate disparity using statistical evidence. So, for example, if females file a complaint of a lack of promotions and raises, then during an investigation, the investigator can take a look at, or management or the person charged with handling these types of cases can take a look at who's been promoted in the past however many years and the raises, and look at it and see if you can find any disparity between males and females, for example. So statistical data can also be used as evidence to show disparate treatment for a particular class. Establishing similarly situated individuals. And I'm going to discuss Title VI as well as Title VII. Title VII includes employment, but Title VI includes students and educational institutions, and they pretty much have the same application for looking at these types of cases. So, establishing similarly situated individuals. Well, similarly situated is any individual in comparable situations or when circumstances are nearly identical. What to consider? Same supervisor? Are they in the same department or unit? Are they subject to the same performance standards? Are they subject to the same policies? For students, do they have the same professor? Are they in the same class? Do they have the same major? And then for both employees and students, do they have the same, or are they subject to the same disciplinary standards? Establishing legitimate non-discriminatory reasons. Respondents or management reasons must be sufficiently clear and specific enough for the complainant to respond and offer rebuttal evidence. Examples of insufficient reasons include Sam failed the course because he did not do a good job on his project without any specific information about why his project was not deemed good or he didn't do a good job. Another example, Ashley did not need the accommodation she asked for without specifying what other measures were taken to provide her with an accommodation. Management must be probed to provide additional details. Earlier, we discussed disparate impact, where a neutral policy or practice or procedure may seem neutral on its surface, but negatively impacts a particular group. So under Title VII, when you're taking a look at disparate impact, identify the specific policy or practice at issue, establish what the harm or the damage was to the particular group, establish disparity, unfavorable treatment by taking a look at similarly situated, and then establish a causal connection or causation and connection between the policy and practice and the adverse action and the harm. Surprisingly, certain discrimination may be actually legal. So when sex, religion, or national origin are considered a bona fide occupational or BFOQ, what this means is that, for example, you need a locker room attendant and it's for female, for example. There may be a need to hire a female for that particular job. Or, for example, a men's identified restroom. you may be able to seek a male for that position. Those are some examples where sex, religion, or national origin are considered a bona fide occupational qualification. I must say, when you think about this qualification, race will never fall under a BFOQ. So pay attention to the protected classes where it may be permissible to recruit or hire um, for particular individuals. And then secondly, when work-related requirements are considered a business necessity. So you may have a business necessity in terms of, someone being able to lift something, and it may be a business necessity for that. But you have to be careful with those types of things. Most of the time, where you may see a work-related requirement, may be we need you to um, you're hiring someone to preach for, Jewish services, for example, for your staff. And so you may need someone that's Jewish or identifies as Jewish, may fall under this category. Third, seniority systems provided for in collective bargaining agreements may make it legal to discriminate against someone where seniority systems have been challenged in the Supreme Court, and it's been upheld that seniority systems that may appear to be neutral through a collective bargaining agreement may be discriminatory towards certain racial groups because they weren't in the workforce as long as non maybe racial minorities, but it's permissible because the courts don't want to, and especially the Supreme Court, they don't want to get into bargaining contracts that were faithfully executed or bargained between management and the unions. And so sometimes this is considered, or most of the time is considered, legal discrimination, even though it may have a desperate impact on a certain group. Transitioning to harassment. So harassment is considered to be a form of discrimination, but it has its own separate definition from discrimination. Harassment is unwelcome conduct that is based on race, color, religion, sex, including pregnancy, national origin, age, so anyone 40 and over, disability, or genetic information. Harassment becomes unlawful where 1. Enduring an offensive conduct becomes a condition of continued employment, or 2. The conduct is severe or pervasive enough to create a work or educational environment that a reasonable person would consider intimidating, hostile, or abusive. Retaliation. Anti-discrimination laws also prohibit harassment against individuals in retaliation for filing a discrimination charge, testifying, or participating in any way in an investigation, so think witnesses, proceedings, or lawsuit, or opposing employment practices that they reasonably believe discriminate against individuals. Most recently, the EEOC, the Equal Employment Opportunity Commission, mentioned that they had findings in retaliation cases overwhelmingly, even when a discrimination or harassment case failed on its merits. So they take retaliation cases very seriously. At Kelly Consulting Firm, we provide a number of services, including consulting, training and organizational development, assessments and studies, culture studies, discrimination, harassment, compliance, diversity and inclusion. We conduct investigations, including EEO, Title VII, Title VI, Title IX investigations, sexual harassment. We also do mediation and alternative dispute resolution, where we can come and actually do the mediations or alternative dispute resolution processes, or we can help you set up your own process. We conduct strategic planning and program initiatives. If you like this Kelly Consulting Firm video, give us a thumbs up and or subscribe to us on YouTube. You can also follow us on LinkedIn, and there's the listing right there on the slide, or on Facebook, and there we are on Instagram.